Suffrage and elections.
Section 145. Persons entitled to vote. Every citizen of the United States of the age of 18 years who has resided in the state 1 year, and in the county 6 months, and the precinct in which he offers to vote 60 days next preceding the election, shall be a voter in said precinct and not elsewhere, but the following persons are excepted and shall not have the right to vote. 1. Persons convicted in any court of competent jurisdiction of treason, or felony, or bribery in an election, or of such high misdemeanor as the General Assembly may declare shall operate as an exclusion from the right of suffrage, but persons hereby excluded may be restored to their civil rights by executive pardon. 2. Persons who at the time of the election are in confinement under the judgment of a court for some penal offense. 3. Idiots and insane persons. The original version of Section 145 confined the right to vote to every male citizen of the age of 21. The prominent woman suffragist Laura Clay asked the framers of the Constitution to empower the General Assembly to grant women the right to vote at some future time, but the delegates rejected the proposal. Although the 19th Amendment of the Federal Constitution, ratified in 1920, granted suffrage to women, the voters of Kentucky defeated a proposed cosmetic amendment that would have deleted the word male from the section. An amendment approved in 1955 eliminated the word male and lowered the voting age to 18. The previous 3 constitutions declared that laws shall be made to exclude from suffrage those who shall thereafter be convicted of bribery, perjury, forgery, or other high crimes and misdemeanors. Section 145 excludes from voting those convicted of treason, felony, bribery in an election, or high misdemeanors, as specified by the General Assembly, those in confinement for a penal offense, idiots, and insane persons. The Kentucky judiciary has held that reside or residence, as used in Section 145, means legal domicile, as distinguished from place of actual abode, and for purposes of voting, residence means a fixed domicile with an element of permanence. There must be an action of abiding coupled with an intention of remaining and making that place one's home to the exclusion of other places, in Everman v. Thomas, 1946. A city council cannot exclude student dormitories from annexed university property to prevent students from voting in city elections. Pursuant to the authority conferred by Sections 145 and 150, the governor can restore voting rights to someone convicted of a federal crime, in Arnett v. Stumbo, 1941. A person convicted of a felony in another state may not vote in Kentucky. The Special Commission on Constitutional Review of 1987 recommended that Part 3 of this section be amended to read, persons who have been determined to be insane or otherwise mentally incompetent by a court of competent jurisdiction, and that an additional sentence be added to read, residency requirements shall be established by law.
Section 146. Soldiers or sailors stationed in state are not residents. No person in the military, naval or marine service of the United States shall be deemed a resident of this state by reason of being stationed within the same. Although the framers of the current Constitution only very superficially discussed Section 146, which is new to this Constitution, its purpose seems clearly to make it difficult for military personnel on active duty in Kentucky to vote in the Commonwealth. Supporters of the section noted that most other state constitutions contained similar provisions. The delegates probably feared that a cluster of armed forces voters temporarily stationed in certain locales could dramatically alter the political reality of those places, a power they did not wish to accord mere transients. The U.S. Supreme Court has invalidated a provision of the Texas Constitution that denied the right to vote to military personnel moving into the state, declaring that such personnel have a constitutional right to satisfy a state's residence requirements for voting, in Carrington v. Rash, 1965. There has been no published adjudication of this section, which the Special Commission on Constitutional Review of 1987 recommended be repealed.
Section 147. Registration of voters, manner of voting, absent voting, voting machines, election defined, election laws, illiterate and disabled voters. The General Assembly shall provide by law for the registration of all persons entitled to vote in cities and towns having a population of 5,000 or more, and may provide by general law for the registration of other voters in the state. Where registration is required, only persons registered shall have the right to vote. The mode of registration shall be prescribed by the General Assembly. In all elections by persons in a representative capacity, the voting shall be viva voce and made a matter of record. But all elections by the people shall be by secret official ballot, furnished by public authority to the voters at the polls, and marked by each voter in private at the polls, and then and there deposited. Or any person absent from the county of his legal residence, or from the state, may be permitted to vote in a manner provided by law. Counties so desiring may use voting machines, these machines to be installed at the expense of such counties. The word elections in this section includes the decision of questions submitted to the voters, as well as the choice of officers by them. The General Assembly shall pass all necessary laws to enforce this section, and shall provide that persons illiterate, blind, or in any way disabled may have their ballots marked or voted as herein required. 19th century Kentuckians voted by voice, viva voce, a system that encouraged the widespread practice of buying and selling votes. To attack this illegal practice, the framers of the current Constitution provided in this section for voting by secret, written ballot. The cities of Louisville and Covington had adopted the secret, written ballot in 1888 and 1890, respectively, in order to curtail vote fraud, which had reached epidemic proportions in those communities. To discourage the rather common practice of voting more than once and in precincts and counties of non-residents, the section also mandated voter registration in cities and towns with populations of 5,000 or more and made such registration optional in communities of fewer residents. The General Assembly adopted the first statewide voter registration in 1886 as part of an electoral reform designed to facilitate voter approval of a constitutional convention call. Pursuant to this section, the General Assembly in 1892 created a voter registration system that was much more elaborate than the one established in 1886, although it only called for the registration of voters in cities of the first four classes. In 1922, the General Assembly made registration mandatory for all voters. In 1941 and 1945, voters approved amendments to Section 147 that empowered the General Assembly to provide for absentee ballots and for counties to use voting machines. Pursuant to these amendments, the General Assembly enacted an absentee voter statute and a statute that requires all of Kentucky's 120 counties to use voting machines. Despite the reforms incorporated into Section 147, the buying and selling of votes continued to flourish in Kentucky until the latter part of the 20th century, when law enforcement officials began to more effectively enforce statutes prohibiting vote fraud. The absence of a considerable number of voters because of service in the armed forces does not invalidate an election, in Karloftis v. Helton, 1944. However, thin ballots in Knoll v. Tinsley, 1899, and open voting booths in Smith v. Jones, 1927, violate the requirement of a secret ballot. The General Assembly can constitutionally require all counties to use voting machines despite the word may in this section, in Lackey v. Garner, 1963. Disabled or ill voters cannot vote by absentee ballot if they are not absent from the county on election day. They must go to the polls and receive assistance there, which they are, by statute, entitled to.
Section 148. Number of elections, day and hours of election, qualifications of officers, employees, to be given time to vote. Not more than one election each year shall be held in the state or in any city, town, district, urban county or county thereof, except as otherwise provided in this Constitution. All regular elections of state, county, city, town, urban county, or district officers shall be held on the first Tuesday after the first Monday in November. All elections by the people shall be between the hours of 6 o'clock a.m. and 7 o'clock p.m., but the General Assembly may change said hours, and all officers of any election shall be residents and voters in the precinct in which they act. The General Assembly shall provide by law that all employers shall allow employees, under reasonable regulations, at least 4 hours on election days, in which to cast their votes. Voters approved an amendment to this section in 1992 eliminating a requirement that local elections be held in years different from the years in which elections for the Federal House of Representatives were held. The purpose of the amendment was to empower the General Assembly to provide for even-year elections for all but statewide officers. The framers of the original provision believed that undue partisanship resulted when local elections were conducted in the same year as federal elections. This section also specifies that except as otherwise provided in the Constitution, no more than one election shall be held in any given year. Section 61 and 155 empowers the General Assembly to provide for different times for local option and school elections. Under the previous constitutions, more than one election could be held during any year, and especially during the period of the Third Constitution, the number of elections held annually became a problem. City, town, state, and federal elections, as well as special elections to vote on proposals to sell railroad bonds and the like, were held at different times. The multitude of elections cost money to conduct and contributed to low voter turnout. This section also requires elections to be held in November. The previous constitutions did not specify months for elections, and the General Assembly provided that August would be the month in which to elect state officers. Most of the framers of the current constitution regarded November as a more convenient month, especially for farmers, and noted that all but a very few states had adopted that month for general elections. The Kentucky judiciary has ruled that Section 148 applies neither to primary elections in Hager v. Robinson 1913 nor school elections in Millett v. Board of Education of Van Leer Graded District 1935, but does apply to county seat location referenda in Walker v. Good 1913.
Section 149. Privilege from arrest during voting. Voters, in all cases except treason, felony, breach of surety of the peace, or violation of the election laws, shall be privileged from arrest during their attendance at elections, and while they are going to and returning therefrom. Similar provisions can be found in the previous constitutions except for the language about violation of the election laws, which the framers of the current constitution added as a further way to discourage the all-too-common practices of vote buying and selling. Freedom from arrest for voters represents a common American liberty designed to prevent the intimidation of voters and to protect the right to vote. The General Assembly has enacted laws to further protect Kentuckians from arrest while voting. In the opinion of the Attorney General, Section 149 prohibits a sheriff from arresting a voter for drunkenness when at the polls or going to or from the polls.
Section 150. Disqualification from office for using money or property to secure or influence election, corporation not to use money or other thing of value to influence election, exclusion from office for conviction of felony or high misdemeanor, laws to regulate elections. Every person shall be disqualified from holding any office of trust or profit for the term for which he shall have been elected who shall be convicted of having given, or consented to the giving, offer or promise of any money or other thing of value, to procure his election, or to influence the vote of any voter at such election. And if any corporation shall, directly or indirectly, offer, promise or give, or shall authorize, directly or indirectly, any person to offer, promise or give any money or anything of value to influence the result of any election in this state, or the vote of any voter authorized to vote therein, or who shall afterward reimburse or compensate, in any manner whatever, any person who shall have offered, promised or given any money or other thing of value to influence the result of any election or the vote of any such voter, such corporation, if organized under the laws of this Commonwealth, shall, on conviction thereof, forfeit its charter and all rights, privileges and immunities thereunder. And if chartered by another state and doing business in this state, whether by license, or upon mere sufferance, such corporation, upon conviction of either of the offenses aforesaid, shall forfeit all right to carry on any business in this state. And it shall be the duty of the General Assembly to provide for the enforcement of the provisions of this section. All persons shall be excluded from office who have been, or shall hereafter be, convicted of a felony, or of such high misdemeanor as may be prescribed by law, but such disability may be removed by pardon of the governor. The privilege of free suffrage shall be supported by laws regulating elections, and prohibiting, under adequate penalties, all undue influence therein, from power, bribery, tumult or other improper practices. The previous constitutions disqualified from public office any person convicted of having given or offered a bribe or treat to procure election or who had been convicted of bribery, perjury, or other crimes or high misdemeanors. This section, for the first time in a constitution, prescribes the forfeiture of the charters of domestic corporations or the right to do business in Kentucky of foreign corporations that directly or indirectly give or offer to give money or other things of value to influence an election or a voter. As in the previous constitutions, persons who hereafter are convicted of felonies and high misdemeanors are excluded from office, with the additional exclusion of those who previously had been so convicted. Moreover, as previously mandated, the section requires the General Assembly to enact laws supporting free suffrage and prohibiting illegal influence on that freedom. The framers of the current Constitution believed that these additional prescriptions were needed to combat increased electioneering illegalities of persons and corporations. In 1927, following the gubernatorial election of that year, the Attorney General of the Commonwealth filed a lawsuit pursuant to Section 150 and legislation, under its authority, to have the charter of the Kentucky Jockey Club forfeited and substantial fines imposed because the club had allegedly engaged in corrupt political activities and unlawful gambling, pari-mutuel betting. Shortly thereafter, the Jockey Club, a powerful special interest, which had been organized in 1918 to operate racetracks and to promote the thoroughbred industry, voluntarily dissolved itself and transferred its assets, Churchill Downs and Latonia racetracks, to a Delaware corporation. The Attorney General nonetheless continued the litigation, contending that the voluntary dissolution was a sham conducted to avoid prosecution and seeking the forfeiture of the charters of the racetracks once owned by the Jockey Club and the imposition of a heavy fine. The Kentucky Court of Appeals affirmed the trial court's dismissal of the charges, ruling that pari-mutuel gambling was legal and the alleged political transgressions were not sufficient to order a forfeiture or to impose a fine substantial enough to warrant a reversal, in Commonwealth v. Kentucky Jockey Club, 1931. The court also ruled that a person is disqualified from public office under Section 150 even if his or her conviction of a felony has been suspended and he or she has been placed on probation. In Woods v. Mills, 1974. Nor does a restoration of rights pursuant to Section 150 entitle a convicted felon to seek a non-elected police officer position, in Leonard v. Corrections Cabinet, 1992. However, in the opinion of the Attorney General, conviction of a mere misdemeanor does not disqualify a person from public office.
Section 151. Person guilty of fraud, intimidation, bribery, or corrupt practice to be deprived of office by suitable statutory means. The General Assembly shall provide suitable means for depriving of office any person who, to procure his nomination or election, has, in his canvass or election, been guilty of any unlawful use of money or other thing of value, or has been guilty of fraud, intimidation, bribery, or any other corrupt practice, and he shall be held responsible for acts done by others with his authority, or ratified by him. While Section 150 prevents individuals convicted of certain crimes from holding office, Section 151 provides for the ouster from office of those who have obtained the office through corrupt means. Section 150 is self-executing, while Section 151 requires legislative action. Pursuant to Section 151, the General Assembly has enacted statutes that define bribery, prohibit the use of intoxicants to influence voting, punish individuals who intimidate election officials, and define and punish other corrupt election practices. The Kentucky judiciary has ruled that the General Assembly has complied with this section, even though it has authorized only unsuccessful candidates and not voters to contest the election of successful candidates under its provisions in Davis v. Stahl, 1941. It also has held unconstitutional under this section a statute that declared elected a candidate who did not receive a plurality of votes in a general election after disqualifying one who did, in McKinney v. Barker, 1918. It further ruled that the section does not invalidate a statute that declares nominated a candidate who did not receive a plurality of votes in a primary election, in Charles v. Flannery, 1921.
Section 152. Vacancies, when filled by appointment, when by election, who to fill. Except as otherwise provided in this Constitution, vacancies in all elective offices shall be filled by election or appointment, as follows: if the unexpired term will end at the next succeeding annual election at which either city, town, county, district or state officers are to be elected, the office shall be filled by appointment for the remainder of the term. If the unexpired term will not end at the next succeeding annual election at which either city, town, county, district or state officers are to be elected, and if 3 months intervene before said succeeding annual election at which either city, town, county, district or state officers are to be elected, the office shall be filled by appointment until said election, and then said vacancy shall be filled by election for the remainder of the term. if 3 months do not intervene between the happening of said vacancy and the next succeeding election at which city, town, county, district or state officers are to be elected, the office shall be filled by appointment until the second succeeding annual election at which city, town, county, district or state officers are to be elected. And then, if any part of the term remains unexpired, the office shall be filled by election until the regular time for the election of officers to fill said offices. Vacancies in all offices for the state at large, or for districts larger than a county, shall be filled by appointment of the governor. All other appointments shall be made as may be prescribed by law. No person shall ever be appointed a member of the General Assembly, but vacancies therein may be filled at a special election, in such manner as may be provided by law. This section limits the power of the governor, who was empowered under the previous constitution to make appointments to serve out the term of vacated state offices, except judgeships, even if only a brief period had expired in the term of the vacated office. Under Section 152 the governor makes only a temporary appointment until the vacancy can be filled by voters in the next general election or, if 3 months do not intervene between the vacancy and the next general election, at the next succeeding election. The governor can constitutionally only fill vacancies in state offices or offices for districts larger than a county. The General Assembly is empowered to prescribe the method of filling all other vacancies, and vacancies in the General Assembly shall never be filled by appointment, but rather always by special election. The Kentucky judiciary has held that Section 152 only applies to vacancies in elective offices, in Rouse v. Johnson, 1930. Presidential electors are state officers within meaning of Section 152, and therefore a presidential election qualifies as a next succeeding election at which state officers are to be elected, in Donnellan v. Byrd, 1904. However, an election for the Federal House of Representatives does not qualify as a next succeeding election within Section 152, in Brumley v. Ruth, 1946. Nor can there be an election to fill a vacancy in the office of circuit judge, when the only district-wide candidate in the general election is for the office of U.S. Senator, in Pierce v. Davis, 1978.
Section 153. Power of General Assembly as to elections. Except as otherwise herein expressly provided, the General Assembly shall have power to provide by general law for the manner of voting, for ascertaining the result of elections and making due returns thereof, for issuing certificates or commissions to all persons entitled thereto, and for the trial of contested elections. The framers of the current Constitution incorporated into this section several sections found in the previous Constitution. The General Assembly has implemented this section by statute. In Pratt v. Breckinridge, 1901, the Kentucky Court of Appeals held that Section 153 does not empower the General Assembly to create a board with judicial powers to try election contests. This case arose out of the contentious election of 1899 and concerned efforts of the Democratic candidate for Attorney General, Robert J. Breckinridge, to be declared the winner of a closely contested election over Republican candidate Clifton J. Pratt. Breckinridge contested the certified election results before the State Board of Election Commissioners, which was created and charged by the General Assembly to judge and settle election contests. The board ruled for Breckinridge, but on appeal the Court of Appeals held that the legislature had created a judicial body not authorized by the Constitution. The court also ruled that Section 153 authorizes the General Assembly by statute to condition the right to vote on the signing of a comparative signature book, in Wilkinson v. Queen, 1954, and to deny the right of a candidate defeated in a party primary to have his name placed on the general election ballot as an independent candidate, in Rosenberg v. Queenan, 1953.
Section 154. Laws as to sale or gift of liquor on election days. The General Assembly shall prescribe such laws as may be necessary for the restriction or prohibition of the sale or gift of spirituous, vinous or malt liquors on election days. Gifts of liquor constituted a commonplace method of buying votes in 19th-century Kentucky, and the free use of intoxicating beverages contributed to the high rate of homicide on election days. Although there was no general law prohibiting the sale or gift of liquor on election days, a number of counties and municipalities during the period of the Third Constitution, 1851 to 1891, had secured local legislation authorizing them to so prohibit, legislation that had reduced election day homicides and the incidence of vote buying in those localities. Believing a general law was needed, the framers of the current Constitution by Section 154 required the General Assembly to restrict or prohibit the sale or gift of liquor on election days. Pursuant to this section, the General Assembly has prohibited the gift or sale of liquor on election day during the hours of voting. While the Kentucky judiciary has ruled that the General Assembly can prohibit the sale or gift of liquor during the 24 hours of an election day, in Commonwealth v. Murphy, 1893, it has also ruled that it cannot prohibit citizens from having in their possession intoxicating liquor for their own use, in Commonwealth v. Campbell, 1909.
Section 155. School elections not governed by Constitution. The provisions of sections 145 to 154, inclusive, shall not apply to the election of school trustees and other common school district elections. Said elections shall be regulated by the General Assembly, except as otherwise provided in this Constitution. The framers of the current Constitution added this section in order to empower the General Assembly to enact laws that continued the existing system of conducting elections for school trustees, a system that differed from the general election system. In many rural areas, such elections were held on days different from general elections, while in urban areas such elections were usually held on the same day as general elections. Moreover, although women generally could not vote, in many districts widows with children could vote for school trustees. Pursuant to this section, in 1893 the General Assembly enacted a statute that authorized widows with school-aged children or wards and spinsters with school-aged wards to vote and provided that elections for school trustees would be held on the first Saturday of June. In 1920 the General Assembly provided that school board elections should be held during the regular November general election. As of 1997, by statute, the legislature requires these elections to be held in even-numbered years at the regular November election, except that school districts embracing fifth-class cities may conduct their elections on the first Saturday in May. In Shields v. Wilkins, 1969, the Kentucky Court of Appeals affirmed a rule established by a series of cases that Section 155 gives the General Assembly authority to regulate public school elections and to fill vacancies on school boards. Thus, it upheld a statute that authorized the State Board of Education to fill by appointment the unexpired term of a school board member who resigned even though that term had more than 3 years to run.
Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book, The Kentucky State Constitution, by Robert M. Ireland, Oxford University Press.